Okay, so in today's update, we are looking into the proposed Bill C12 from the federal government of Canada and what it means for immigration applicants. For example, study permits, work permits, economic immigration programs, spousal sponsorship applications, entrepreneurs, and even business immigration. Now, the idea is to strengthen Canada's borders, and that means to give certain powers to CBSA, RCMP, and other law enforcement agencies. But we are concerned about its impact on the immigration side. And that means there are certain powers that are given to IRCC, which allows them to cancel, suspend, or even refuse the applications that are in process at the moment. So who should be concerned about Bill C12 and its impact? Which clients are at more of a risk? So if Bill C12 passes and it comes into force, let's look at the applicants that are more likely to be at a risk. Startup visa applicants, they could be canceled under Bill C12. Pending immigration applications in backlog streams. So if you file a PR or economic immigration application that has been pending for a long time, this might be a concern for you. So if your application is in process, let's say for a number of years, and a decision has not been rendered, chances are you could be impacted. And for refugee claimants, Bill C12 could provide provisions that could reduce rights of refugee decision-making. It can block hearings or shift claimants into lesser systems. So if your file falls into one of these categories, for example, it's related to the startup visa program, or you have a long pending applications that's been pending for a number of years and a decision has not been rendered. So this means you should consult your immigration consultant or immigration lawyer and ask them about the next steps. Which applicants do not need to take unnecessary stress under the BC12 if it comes into force? So applicants in more standard mainstream immigration streams with strong compliance and shorter processing time, and your application is proceeding normally. You are not in the frontline risk. Or simply applying for an extension, like a study permit or a work permit, and your file is in good standing. And clients or applicants whose immigration strategy is clear, straightforward, and it's compliant. The likelihood of you facing a negative impact on your file is pretty low. So given this information, as an RCIC, these are my recommendations for you. Ask your advisor for an update. Are you in a backlog situation? Is it the case that you haven't had a decision rendered for a number of years? Or is your immigration stream subject to a cancellation risk? The stronger your file, the less likely that you'll face this discretionary cancellation. And you do not need to panic unnecessarily. And finally, if you are working with me or with any other RCIC, we'll proactively assess whether your pathway could be affected by Bill C12 and adjust the strategy as required. If you still have questions or concerns and you need more information, or you need some sort of legal advice, you can book an appointment at the given link here. I'm a licensed Canadian immigration consultant based in Toronto, Canada. We'll talk about your specific situation, and of course, we'll let you know how to move forward. Anyways, that's it for now, and we'll come back with more updates. Thank you.